Committing certain actions against families of law enforcement officers constitutes an offense under Section 60B of the Crimes Act 1900, which carries a maximum penalty of 5 years in prison. To establish the offense, the prosecution must prove beyond reasonable doubt that 1. You assaulted, stalked, harassed, or intimidated a person who had a domestic relationship with a law enforcement officer, or you obtained the personal information of such a person intending to use it to cause fear of physical or mental harm to an officer. 2. You intended to cause the officer to fear physical or mental harm. And 3. You engaged in the conduct because the person was a law enforcement officer, or due to, or in retaliation for, the actions of the law enforcement officer. An assault is where 1. You caused fear of immediate and unlawful violence, or you made unauthorized physical contact. 2. The other person did not consent. And 3. Your actions were intentional or reckless. Stalking includes any of the following if it is done without consent. 1. Following a person about. 2. Watching, approaching, or attending a person's home, work, business, or place of socializing. And 3. Making repeated contact with a person. Courts must look at any pattern of behavior when determining whether conduct amounts to stalking. Harassment has been defined by the courts as pestering, badgering, or persistently applying unwanted pressure. Intimidation includes 1. Harassment or molestation. 2. An approach, whether physical or otherwise, that causes a person to fear for his or her personal safety. And 3. Causing a person to apprehend injury, violence, or damage. A person with whom the officer has a domestic relationship includes 1. A spouse or de facto partner. 2. An intimate partner. 3. A child or current or former relative. And 4. A person living in the same household as the officer. Law enforcement officer is defined as 1. A police officer. 2. An ICAC commissioner, assistant commissioner, or officer. 3. An officer of the Law Enforcement Conduct Commission. 4. A NSW crime commissioner, assistant commissioner, or staff member. 5. A corrective services commissioner or governor or correctional or corrective services officer. 6. A juvenile justice officer. 7. A crown prosecutor, acting crown prosecutor, or DPP lawyer. 8. A sheriff's officer. 9. An officer of a charity who performs animal cruelty investigations. And 10. A special constable or other person recognized as a law enforcement officer under the Police Act. The prosecution does not need to prove that any person was actually assaulted, stalked, harassed, or intimidated, or that the law enforcement officer feared for his or her safety. Causing the officer to fear harm includes causing fear of harm to a person with whom the officer has a domestic relationship. Duress, necessity, and self-defense are legal defenses to the charge. In the event you are able to raise evidence of a legal defense, the onus then shifts to the prosecution to prove beyond a reasonable doubt that the defense does not apply in the circumstances of the case. You are entitled to an acquittal if the prosecution is unable to do this.
Going to court. Call Sydney Criminal Lawyers on 9261 881 to arrange a free first conference. Watch our latest video here.